Imagine you're driving home when suddenly you see blue lights flashing behind you and now you realize you're being pulled over. Now imagine the officer walks up to your window, knocks on the window, says you're going to have to get out because he has probable cause to search you, your car, and all of your property, and you don't realize that he's using a legal myth to get around your rights. In this video, I'm breaking down number 1, the specific legal myths cops use to get around your rights, and number 2, the exact phrases, the specific legal terms you can use to stop them dead in their tracks. Stick around until the end, because missing the difference between myth and reality can cost you your privacy, your time, and maybe even your freedom. Myth number 1. If you're arrested, police can search anything you have, your bags, your purse, or any other property. The reality, police can search you and the area immediately around you that you can grab, but they cannot just search anything and everything else that's not within your immediate reach. In that situation, the rules get a little more complicated. Once an item is under the officer's exclusive control, they can't just start searching without a warrant. They're either going to need a valid search warrant now, or they're going to need an inventory policy they can follow in order to see what's inside. I see this happen all the time. Cops arrest someone or detain them, and they think they can just start searching everything like they do their pockets. They think they can start searching their backpack, maybe their briefcase, or anything else that they have, claiming they don't need a warrant. But courts have been very clear that you have a privacy interest for things like luggage, baggages, even your digital interests like your phone. In the United States Supreme Court case of U.S. versus Chadwick, the Supreme Court threw out evidence obtained from cops searching a footlocker that the driver had loaded into his car. The footlocker was actually seized at the time of the driver's arrest, but it was opened over an hour later at the police station. The court held very specifically that once the property was within the control of the police, the actual arrestee could no longer gain access to it, so it was no longer justified to be searched incident to arrest. Well, think about it. The core reason for a search incident to arrest, according to the U.S. Supreme Court, is that they want to protect police officers' safety from the person being arrested gaining access to the property, or to make sure that no evidence is being destroyed if the actual person being arrested could get access to the property. But once the cops have exclusive access to it and you no longer have access, all of those excuses go out the window. Cops can't just search whatever they want just because you were being arrested. Now, the interesting part of this is what type of property can be actually seized and searched incident to arrest, and what other type of property requires a warrant. For example, let's say a police officer chooses to arrest someone and they find a wallet or a purse on them, but then separately they also have maybe a backpack, maybe a piece of luggage, or maybe even their cell phone. Now, when you're talking about a wallet, something in your pockets, cops can actually take those items and search them incident to arrest. That's okay under Supreme Court standards under Chadwick. However, the problem's a little bit different now for the police. If they're wanting to search your backpack, or maybe they're wanting to search your luggage, or even your cell phone, here, it's not immediately associated with your person. It's a separate piece of property that you have a privacy interest in. Police now are going to have more, they're going to need more legally in order to just search that property. Now, police try to get around this provision by performing an inventory search on your property, and we'll get into that later, but it's important to understand that they cannot just decide to search anything and everything that you have on you just because they're placing you under arrest. So how do you protect yourself here, and what are the words you need to use in order to stop cops? Remember, if you have items that are in your pockets, on your person, you could end up having an officer justify being able to search those without your consent as a search incident to arrest. However, any items that you carry that's separate, like a backpack, something very important, maybe like a briefcase or luggage, in that situation, cops cannot just search all this other property that you might have that's separate from you without a valid warrant or under their inventory policy. So what are the words you use here? Officer, I do not consent to a search and will not answer any further questions without my attorney present. This is really important because police officers will look down and go, hey, what you got in the luggage down here? What you got in this briefcase? Listen, you mind if I take a look? If you don't let me take a look, this is not going to go very well for you. And I'll just do what it takes in order to get to it. So it'll make it all easier for all of us if you just go ahead and let me look at it now. Remember, this is the officer trying to bait you into it to make it feel like it's inevitable that he'll be able to get into your backpack or into your luggage or whatever else you have. That is just not the case. You have an absolute constitutional right to refuse consent to search. Oh, and as a practical matter, if you value your privacy, don't store whatever that thing is that you're private about. Don't store it in any type of container where a weapon might easily be located. That will give the officers an opportunity to try to claim for their officer safety. They were able to do a periphery initial search scan for weapons in order to protect themselves. Myth number 2. If I'm not free to leave, then that means I'm in police custody and cops have to read me my Miranda rights. The reality, seizure and custody are two different concepts. You can actually be not free to leave, according to the police, and they still don't have to read you your Miranda rights. This is so very important. Reading your Miranda rights, getting your Miranda rights read to you by the police is only required if you are under what's known as custodial interrogation. That means you have to be in custody, not free to leave, so to speak, but then also being actively questioned. You must be actively questioned by the police. There's a very clear distinction that's made by the Supreme Court here. So many people I talk to think that any stop or detention by the police means they have to immediately read you your Miranda rights. Unfortunately, that's just not the case. In fact, Miranda gave us a test for custody, what it means to be in custody. They gave us a specific phrase under Miranda versus Arizona. It says, would a reasonable person in your situation feel that your freedom of movement is restrained to the degree associated with a formal arrest? If the answer is no, and you don't meet that custody test, then whether a cop pulls you over at a traffic stop or walks right up to you on the side of the road, as we would call a Terry stop, cops can ask you all kinds of questions and they don't have to read you your Miranda rights. In fact, in the Supreme Court case of Berkmer versus McCarty, they said specifically that traffic stops do not meet the definition by themselves of being in custody, requiring Miranda rights to be read to you. Why? Because the Supreme Court said they are typically brief, they're taking place in public, and you're not being physically restrained by the police in any way. That's why cops can easily start asking you all these fishing questions where they ask things like, where are you going? Where you been? Where are you headed? You had anything to drink tonight? It's only if a traffic stop escalates to the place where you're getting pulled out of the car, maybe you've got handcuffs on or you're being detained in the squad car, that's when Miranda rights would be required to be read if the officer's trying to ask you any questions. The same thing would hold true if the cop walks up to you on the street, what we call a Terry stop. Let's say the cop thinks you're up to no good, right? And he walks up and he starts asking you questions. Technically, that is not seen as being in custody, requiring Miranda rights to be read to you. The real test here is if it's a brief detention and limited scope, just basic questions here, Miranda rights are likely not required. However, if cops have guns drawn, maybe you've got your cuffs on behind you, you're surrounded by police officers, that's more of an arrest, more of an intimidation situation. Now it's more likely Miranda rights would be required. So being placed in a locked police car, that's definitely in custody and Miranda rights are required. Placed in a police interrogation room, watch out. Police love to try to say things like, oh, you're free to leave anytime you want to. Just have a couple of questions for you. It depends on the context. If the door's being blocked and you can't walk out the door, or it's an intimidating situation, Miranda rights are required no matter what the cop says. But if it's a pretty inviting situation, cops have many times said, no, you still have the right to get up and leave whenever you want to. Watch out. Cops love to use this myth and this trick in order to get you to give up your rights. So what words can you use here to avoid being tricked by these cops in this situation? Now, cops know these rules really well, so they might try to trick you a little bit by saying, hey man, look, you're not under arrest. I just have a couple of quick questions for you and we'll just let you go. In that situation, even though you're not in custody, they want to make you feel comfortable to start talking because now they didn't need to read you your Miranda rights and anything you say can be used against you. So if you decide to talk to the police, which I recommend that you do not, you need to think very clearly about whether it's worth doing that. If you decide to talk to the cops, if you start feeling things becoming accusatory and maybe getting a little out of control, you can tell the officer, at this time, I exercise my right to remain silent and I will not answer any further questions without my attorney present. When in doubt, if cops are opening their mouth and they're talking to you, it's the best time for you to exercise both your Fifth Amendment right to remain silent and your Sixth Amendment right to counsel. Myth number 3, after I've been arrested or detained, police can search everything in my pockets, even my cell phone. The reality? No. The Supreme Court carved out special rules for your cell phone and digital devices in the Supreme Court case of Riley versus California. In this very important 2014 case, the United States Supreme Court ruled that cops must obtain a warrant to search anything in your phone, absent exigent circumstances like an actual emergency. Your phone is not like anything else that you carry on your person. It holds so much of your data and your personal information that the Supreme Court has said it's too personal, too much of a privacy interest, so cops have to get an actual warrant. In fact, the court said in Riley, not only about cell phones, but about any type of device that holds your digital data. They said, and I quote, "The police generally may not, without a warrant, search digital information on a cell phone or other items seized from an individual who has been arrested." They went on to say, "The usual justifications for search incident to arrest do not outweigh the privacy concerns for digital data." So how much are you actually protected here? What this really means that is if you're detained or arrested, cops can actually secure your phone, but they cannot go through it and look through any of it unless they have a valid search warrant. However, there are some things that are common on many smartphones now that will completely destroy all of your privacy rights when it comes to your phone. One of the biggest things out there is using biometrics. Maybe it's the fingerprint reader. Maybe it's your facial recognition. Cops all the time, there's been many cases out there establishing case law that cops can actually take your finger and force it onto your biometrics to get access to your phone, or just hold the phone up to your face, and this is not considered a Fifth Amendment violation by the equivalent of you giving out your passcode. Some courts out there have held that that is not a violation and that it's essentially a way for police to be able to obtain consent. They analogize it that it's similar to taking a DNA sample. You didn't say anything, they just collected something from you. So we're going to get into some specific measures you can take here, but watch out for using biometrics on your phone. What if cops decide to search your phone anyway, illegally? Remember, in that situation, don't fight them. Just realize the law is now on your side. If they try to proceed searching through your phone or digital wallet of some sort, and do so without an active, valid search warrant, it is now an illegal search, a violation of the Fourth Amendment, and not only can you have that evidence suppressed, you can actually be able to move forward with this, gain access to your original evidence on this. And yes, I understand qualified immunity exists and there's other issues that are out there, but they're not going to be able to use these items against you. So how do you protect yourself here? What are your magic words you can use if cops start trying to dig into your cell phone and other digital items? First, you must always make it crystal clear you do not consent to a search of your phone or any other items, your person, your property, or any other digital items that you have. Then never, I mean never use biometrics on your phone. Otherwise, depending on your jurisdiction, cops may try to force that phone, your phone, up to your face for facial ID to get access to it, or they may try to put your fingerprint actually on the fingerprint reader and get access to your phone data. Instead, use a strong passcode and don't voluntarily hand any of it over unless you don't care about your privacy. Well, even if you think, and this is what I hear all the time, well, I don't have anything criminal or illegal on my phone. I don't care if cops dig through it. I guarantee you, if you wouldn't want a stranger digging through your phone, why would you want police digging through your phone? Being able to look and laugh at pictures or anything else that you might have, and you never know. People have a tendency to see what they want to see. And if cops don't like something they see on your phone, now all of a sudden you're being investigated for something you didn't even do. So your magic words here is I do not consent to a search, I will not answer any further questions, and I exercise my right to remain silent, and I want my lawyer. Even if they try to use some of these tricks like, hey, this is going to go easier for you if you just let us take a look at what's in your phone now. I promise you I'm not going to work with you, and I'm going to go straight to the DA and make this hard on you if you don't work with us now. These are all tactics trying to get you to hand over your constitutional rights, so stand firm and use your words that we just covered. Myth number 4. Police can always pat you down for officer safety for any stop. Reality, officers cannot, and I want to be very specific about this, pat you down for a search for weapons without, and I quote, specific, articulable, reasonable suspicion that you are armed and dangerous. In other words, cops must have particular facts that you are not just armed, but that you are also dangerous. They have to paint a picture. It's not illegal, particularly, well, depending on your state, I guess, to actually be armed in your vehicle. So being armed and dangerous are two separate things. It must be armed plus dangerous. So just because they think you are armed does not necessarily by itself allow them to now be able to perform this pat-down search for weapons. In the Supreme Court case of Terry versus Ohio, the Supreme Court allowed for a pat-down of the outer clothing of someone during a traffic stop if the officer believed that he was carrying a weapon and he might be dangerous for officer safety's sake. The problem is many cops now use this as a catch-all excuse to say they don't like something about you. Now they want to pat you down to see, for officer safety's sake, if you might be having a weapon. Let me be very clear. That is a misapplication and a misuse by police of Terry versus Ohio. The court was very clear that there must be a specific suspicion here involved. And what do we mean by specific suspicion? Some examples of armed and dangerous facts that held up in court. Number one, a bulge that looks like a gun in someone's pocket. Movements toward a particular pocket where someone looked like they were pulling out a weapon. Maybe a violent crime situation that someone's being suspected of and they're putting their hands in their pockets. Nervous behavior consistent with carrying a weapon. Chief Justice Earl Warren specifically said there must be a, quote, justified belief that the individual is armed and dangerous. It can't just be, ooh, this is a bad neighborhood here, and I think everyone around here is suspicious, so I'm patting you all down. If there is this justified belief that someone is armed and dangerous, the cops can only do an immediate pat down of the outer clothing, and they can only go deeper to see what it actually is in the pocket if it is a, quote, immediately apparent that it is a weapon or contraband involved. In other words, Terry versus Ohio was very clear that a pat-down search like this was never meant to be just a search-all. Just look for whatever we want, stick our hands in there and pull whatever we want out. It must be immediately apparent that it is a weapon or contraband, and if not, they are not allowed to continue to dig. So how does all this play out? Let's say that you're walking at 2 a.m. coming back from a friend's house, and let's say you jaywalk across an area. No one else is on the road. You walk across, and the officer pulls you over there. He starts talking to you. He has no basis whatsoever or no reasonable suspicion to do a frisk on you because there's no objective evidence that his safety is at risk. Now, if you're in a high crime area and you jaywalk across the street, and when the officer comes to pull you over, you start acting skittish, you start putting your hands in your pocket, you start reaching to grab for something, doing all these furtive movements, the officer may be able to articulate their specific beliefs, specific facts, articulable facts that you may be armed and dangerous. But just saying it was a traffic stop and it was late at night, so I'm going to pat you down, that is illegal. So how do you protect yourself here? If cops just pull you over or walk up to you and they want to search you for no good reason, listen, this is going to seem like a theme to you, but over and over again, your rights are only worth it if you exercise them. They're literally worthless if you do not exercise them by using them and opening your mouth and saying, officer, I do not consent to a search. And you need to make that crystal clear. Now, I don't suggest you resist the pat down because that could be dangerous. But if you have anybody with you, they become a witness to the fact nothing here actually happened. If your phone is recording, if you have the audio going, if the officer's body cam is going, you can show objectively that they did not have a justified belief, as Chief Justice Earl Warren said, that you were actually armed and dangerous here. But what if instead of patting you down, cops now want to get into your house? This brings us to myth number 5. Police can always go into a house if they saw someone going inside or if they already had an arrest warrant. The reality, officers cannot just barge into someone's house, even if they have a valid arrest warrant or they may know that the person's inside, unless they meet certain conditions. This is really important because the Fourth Amendment's standard for privacy and protection for your home is the strongest of anywhere else in the country. In the Supreme Court landmark case of Payton versus New York, the Supreme Court held that officers, if they have a valid arrest warrant, can enter into a suspect's home if it's the residence where they live, if they have good reason to believe that that suspect is in the home at that time. But, and this is a very important but, this same rule does not extend to homes of third parties. In other words, if the person listed under the arrest warrant is actually in another person's home, that is not enough for an officer to use that arrest warrant to barge into this other person's home. In that situation, cops are going to have to get a separate search warrant for the third party's home in order to go in and look for the person. So let's break this down very simply. The Payton rule basically says that if cops have a valid arrest warrant, they can enter into that same person's home, their residence, and they don't need their consent. They can enter into that home as long as they believe that individual is in the home at that time. This even applies to minor offenses. This can be both felonies and misdemeanors. The court made no distinction between this as long as they're a valid arrest warrant. But what if it's someone else's home? This brings us to the Stiegel case. In Stiegel versus United States, there was a situation where a fugitive, federal authorities had an actual warrant for a fugitive by the name of Lyons. But Lyons was hanging out at Stiegel's house. So the authorities showed up at Stiegel's house and said, hey, we've got a warrant, a fugitive warrant for Lyons. We're coming into your house to get him, and we're going to do it right now. Once they entered into Stiegel's house, what did they find? They found illegal drugs there, and they arrested Stiegel. The Supreme Court said this was an illegal entry. Why? Well, because it makes sense. Cops need a separate warrant in order to enter into a third party's home when they had no basis to ever be there to begin with. In fact, the court drew a bright line. I'm going to read to you the exact quote. They said, and I quote, "A home may not be searched without a warrant, except consent or exigency, and an arrest warrant addresses only the arrestee's rights, not the homeowner's." The best way for me to illustrate this is through an example. Let's say the police have an arrest warrant for Greg. They go to Greg's house, and Greg's wife says he's not here, he's at Grandma's for dinner. If officers believe his wife, they can't just storm Grandma's house with an arrest warrant looking for Greg. Grandma never gave consent, and Greg doesn't legally live there. The only way that the cops could go into Grandma's house looking for Greg is if they either received Grandma's consent, they had a valid search warrant for Grandma's house, or there was some exigent circumstances, like they heard screaming going on at Grandma's house, or maybe they actually saw Greg trying to jump out the side window. Now, here's the trick Grandma has to watch out for, because they'll say things like, "Ma'am, I think you're harboring a fugitive. You better give up Greg right now, or we're going to arrest you for a felony and you're going to jail." Grandma better watch out and realize this is nothing more than a police lie and a police trick. Because if cops try to force their way into her house, which she has a separate privacy interest for, that is actually a Fourth Amendment violation, and the cops are merely trying to trick her. The key point here is, how do you protect yourself, and what are the words that you use to make sure and push the cops away? Because we know our home is our castle, if someone ever shows up at your house looking for someone else, number one thing I would advise you to do, don't even open the door. If you are going to talk to the cops, I would do it with the door closed, and I would let them know, "Officer, I exercise my right to remain silent. I do not consent to a search, and I will not let you in unless you come back with a specific search warrant with my name and address on it." Now, what if cops show up at your front door claiming they have an arrest warrant for you? Well, remember, one of the requirements of Peyton is that they have to have good reason to believe you are presently at that location. Well, if you don't answer the front door, if you don't make any noise, they're not going to necessarily know that you're actually there. So one of the big mistakes people make is they try to answer the front door, and they try to now talk themselves out of being arrested on that warrant. It's never going to happen, and it's not going to work. If the cops are going to come in, they're going to come in regardless of what you say one way or the other. So one of the things you can do is literally ignore the officers at the front door. You have no legal requirement to open that door. And if the officers cannot establish that they have reason to believe you are inside the residence, they're not going to be able to come inside. Now, we just covered 5 myths cops love to use against you and the exact words you can use to shut them down. And by the way, I got another video where I'm covering many more. But did you know cops can lie and ask you dumb questions legally and get away with it unless you know the right responses? Check out this next video where I cover police lies and dumb questions and the 10 best responses to protect yourself. See you over there.